Okay, looks like we have a good chunk of people who have logged on. So, hello again, everyone. My name is Caroline Kane. I'm here with my colleague, Hope Harriman, and we are both attorneys at Franzik. And our practice focuses on labor and employment issues, both for private and public sector employers. Hope and I are both excited to be here with all of you today to provide a legislative update in the area of labor and employment law. This is a 30-minute webinar, so we are going to take you through some highlights of Illinois legislation that went into effect earlier this year. We'll address, I guess, what you need to know about these laws as Illinois employers. We will also be discussing legislation that will become effective soon that should be on your radar for the upcoming year. So if you have any questions, please feel free to use the Q&A function that should appear on your screen, or shoot us a chat and we will do our best to answer your questions in real time. If we are unable to get to your question, please feel free to follow up with us directly after the webinar, and Hope and I are both happy to speak with you and discuss any questions you may have. So with that said, let's dive in. Um, so first, Hope and I are going to take you through legislation that was in effect as of January 1st of this year. And the first batch of slides we have to do with the Illinois Human Rights Act. I would guess that many of you are very familiar with this act. In short, it is an Illinois law that prohibits discrimination, harassment, retaliation based on various protected characteristics in employment and other areas as well, such as housing and public accommodations. It's similar to Title VII of the Civil Rights Act, which is its federal counterpart. So as of January 1st of this year, the statute of limitations has been amended so that employees now have 2 years to file a charge of discrimination with this Illinois Department of Human Rights, which is the agency that investigates these charges before the case proceeds to court. Previously, a complainant only had 300 days to bring a charge, so it is now elongated as of January 1. So notably, this does not extend the statute of limitations for federal claims under Title VII, which must be brought before the EEOC. These claims are still subject to the 300-day limitations period. So frequently, complainants will cross-file their claims both at the Illinois Department as well as the EEOC. So now, given the elongated statute of limitations under the Illinois law, we may start seeing claims that proceed at the state level that are older and unable to proceed at the federal level. Okay, and the Illinois Human Rights Act was also expanded to include a prohibition of discrimination and harassment against individuals based on family responsibilities. So, for those of you familiar with the Illinois Human Rights Act, you know that the act already had a list of defined characteristics that were protected, such as race, color, religion, national origin, sex, among many others. It has now been expanded even further to include family responsibilities. So this is defined as the employee's actual or perceived provision of personal care to a family member. So personal care means activities to ensure that a covered family member's basic medical, hygiene, nutritional, or safety needs are met, or to provide transportation to a medical appointment if your family member is unable to meet that need himself or herself. It also means being physically present to provide emotional support to a covered family member with a serious health condition who is receiving either inpatient or home care. And the law applies to certain family members. So this is a defined, I guess, category of family members this applies to. It can be the employee's child, stepchild, spouse, domestic partner, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, or step-parent. So now, while the act prohibits an employer from discriminating or harassing an employee based on their family responsibilities, it does not impose any new leave or accommodation requirements on employers. Next, the Illinois Human Rights Act was also amended to include protection for employees' reproductive health decisions. So the act now prohibits discrimination based on um, reproductive health decisions, which is defined as a person's decisions regarding their use of contraception, fertility or sterilization, assisted reproductive technologies, miscarriage management care, health care related to termination of pregnancy, or prenatal, intranatal, or postnatal care. Next is our last update to the Illinois Human Rights Act. The act was amended to allow courts to impose restitution to any party who has found to be injured by a pattern or practice of discrimination. The act further clarified that in imposing a civil penalty, each instance of discrimination and each party harmed may constitute a separate violation, which could increase potential damage liability. Um, so there is an increased maximum civil penalty that a court could impose for unlawful discrimination, according to the new amendments. And this ranges anywhere from $50,000 to $100,000 per violation, depending on whether this is a first time offense or whether there were previous violations in the past 5 years. The act also was amended to allow the Illinois Department of Human Rights to establish a hotline, which will be available to those who want to report discrimination. And that wraps up our amendments to the Illinois Human Rights Act.
Thanks, Caroline. So as Caroline mentioned, my name is Hope, another attorney here at Franzik, and I'll be covering a few additional updates outside of the Illinois Human Rights Act. So the first we wanted to bring your attention to are some new E-Verify rules. Now, E-Verify is the system that the electronic system basically that compares a worker's Form I-9 information, their worker eligibility forms, to the government databases to verify employment eligibility. So as an employee typically is being onboarded, employers are asking for passports, other documents, and running these against government databases to verify employment eligibility. Now, this amendment, as we said, this is all Illinois legislation. So this is an Illinois law. There are separate federal laws about this, but Illinois law here is that this is an amendment to the Right to Privacy in the Workplace Act in Illinois, where these issues are covered. So the amendment here adds that an employer is not required to enroll in the electronic verification system. This can be done non-electronically. And there are no, and of course the employer may do so, but is not required to. So in addition, this is a pretty hot button issue, especially recently given changes in federal priorities for enforcement. And so we're really reading this Illinois law as one that expands protections for employees within the state of Illinois. For example, there's several details that add to this, but a few that we want to draw your attention to. So first, the act added that an employer cannot impose work authorization or re-verification requirements greater than anything required by federal law. So federal law is the floor to these types of rights, and often states can impose, as long as it doesn't contradict federal law, additional requirements. But this law in Illinois is saying, hey, no more requirements than the federal law already provides. Now there's some changes as to what an employer can do or must do if there is any discrepancy. So what can happen is an employee can upload their documents and it may ping the employer saying, hey, these documents don't match what's in our government system, flagging that there might be a work authorization issue with the employee. So if the employer contends that there is some discrepancy in the employee's verification information, the employer must provide certain information to the employee. Now, these are new requirements that were not previously enacted. So first, the employer has to give the specific document or documents that the employer thinks are deficient, and they have to give the reason why they think those documents are deficient. So additionally, after request from the employee or the representative, they have to give over the original forms and a basis for why they think that those documents are deficient. So this is really just increasing the information that the employee gets by statute, that the employer is going to have to go through these obligations to make sure that the employee is appropriately informed. They, along with this, have to give the employee instructions on what the employee can do to correct any of the alleged deficiencies, and an explanation to the employee of their right to have representation at any meetings. Additionally, employers can receive notice from agencies. So for example, a federal agency or a state agency, such as the Social Security Administration or the IRS, that there's a problem. Now, if the employer is getting these notifications from an external agency, the employer still has obligations. So importantly, the employer can't take any adverse action against an employee if it gets one of these notices, including requiring the employee to e-verify. So for any employer who's receiving, and these may come with increased frequency, again, given the shift in enforcement priorities at the federal level, it's possible that these could come through. So this should, kind of sound an alarm for the employer to remember that there are protections and obligations that the employer has if it's getting these pings about possible discrepancies. Then, not only can you not take an adverse action as an employer, but then 5 days after the receipt of this notification from an agency, hey, there might be some problem, the employer again has to provide notice to the employee about the discrepancy, and again, notice that the employee can have a representative at their choosing present at these meetings. Now, there is also a separate process where these forms can be inspected. So an inspecting entity can come in and check an employer's employee verification forms. So if an inspecting entity notifies an employer that an employee is not authorized to work in the United States, again, more notice requirements here. The employer has to provide written notice to the employee of this issuance within 5 business days, and by hand if possible. So delivering this to the employee in person if possible. If not, there are options for mail and email or notifying the employee's representative. So, the big takeaway here is where, this is not the first time that we're seeing conflicts between, or tension between state and federal law. And this is one case where employers should be very mindful that in Illinois specifically, there's going to be a lot of protections and safeguards in process, representation, and notice that employees are now entitled to. So next, personnel records. This is a little bit of a smaller change, also effective this year. So prior to this change, an employee always had a right to get their personnel documents. That's not new. What is new is that now if an employee submits a written request to their employer, the employee has the right to inspect, copy, and receive copies of not only their personnel documents, which had always been the case. And personnel documents here is specifically defined in the statute to include things that determine employment qualifications, promotion, transfer, compensation, benefits, discharge, or other disciplinary action. Now the amendment is adding some new things. So an employee can also get any employment related contracts or agreements that the employer maintains that are legally binding on the employee. So think of that as, anything that the employee is signing when they're, first signing on to the job, whether that be an employment agreement or some other type of agreement. Any handbooks that the employer has made available to the employee and that the employee has acknowledged, and then any policies or procedures. So pretty similar there. So, employers need to be careful to keep records and copies of all of these documents now that they are being made available to employees where previously they were not. So another small change, that before this amendment, an employer could require that an employee's request be in writing, and now the act has been amended to just say, hey, these requests need to be in writing. Finally, there's a new specification in this amendment that if an employee alleges that their employer has violated the act, they have a right to file within specifically 180 days to enforce their rights as to this act in court. All right, pay transparency. This is a big one. Hopefully, for all of our Illinois employers joining us here today, a lot of steps for compliance on this one have already, come through, and I have seen a lot of employers now in Illinois, posting their job requirements in accordance with these new rules. So that's great to see. So again, effective January of this year, so we're in full swing now. This amendment to the Equal Pay Act in Illinois is requiring employers to increase transparency about their pay. So first applying to employers with 15 or more employees. So that's going to be a lot of folks. And they must include pay scale and benefits in all job postings, including, so if you're using a third-party service, say LinkedIn or something like that, that employers who are using those have to provide the third party with the pay scale and benefits information in order to make the posting for them. In addition to this, there are some rules about posts for promotion for internal employees. So an employer has to share opportunities for promotion within 14 days of an external job posting to current employees. So whenever if you're an employer and you're going to post a new role, this should be triggering several things for you now. First, to decide, what the pay scale is, what the benefits are, and to make sure that those are posted, and to share those opportunities within 2 weeks to current employees. Now, I will add sort of the backdrop of all of this is that, of course, if you are going to be posting the pay scale for your roles, and those were previously not public, that is going to trigger potentially a separate issue that you want to make sure as the employer that your pay scale internally is lined up. So you need to be comfortable with what you're paying, which position, and why. Because now, of course, if the job posting is public, anyone applying for the role is going to be able to see it, but your current employees are also going to be able to see it. Now if someone who has your data analyst role sees a data analyst role posted, that's going to have the pay scale. And so they're going to know, just what the company says it is going to pay for people in that position. So this is just another push for employers to, we're always encouraging folks to, conduct audits of their pay practices to make sure it's in line with law and business priorities. And this is a really good push to do that. Because of all of these new obligations, employers do have to preserve records now of pay scale and benefits for every job for up to 5 years. There are a lot of fines associated with not complying here, and there is a cure period, but we're hoping that employers can get this out of the gate and avoid any of those consequences. One caveat here that has come up for some folks is that nothing in the act prohibits an employer from asking an applicant about their salary expectations. I mean, that's a pretty routine part of, job negotiations that, hey, what are you expecting for the role? And they're going to see it in the post, what we offer. Doesn't mean the employer can't negotiate or get a picture of where the employee's at. This is just level setting what the employer is required to post. All right, whistleblowing. Again, some minor changes here. This is more like the small amendments to the Whistleblower Act, not a huge overhaul like we've seen in some of the others. So this is Public Act 0867, and it's amending the Whistleblower Act, really increasing protections again for employees. So basically what this is doing is increasing the scope of protected employee activity. So kind of big picture on whistleblower law is that, employees, if they file certain complaints regarding misconduct, that they're protected from retaliation for those things. Now, the Illinois law here, there's already this bedrock protection in Illinois. What is different now is that what is protected activity is a little more broad. So it now includes an employee's report or threat of report about information related to activity, policy, or practice of the employer where the employee has a good faith belief that that activity, policy, or practice violates a law, rule, or regulation, or, according to the text of the amendment, poses a specific danger to employees' public health or safety. So the key things to know here is that this good faith standard, now it's saying an employee has to have a good faith belief, is a little different and I would argue more generous than what existed before. Before it was reasonable belief, reasonable implying some objective criteria about whether the belief, a reasonable person could believe that their employer was violating policy. Now we're seeing good faith belief, as in if the employee truly, actually in good faith believed that there was a problem, no reasonableness requirement, they're protected from making these types of reports. So last thing that was expanded is this activity, policy, practice. So this is again expanding the types of things that an employer, that an employee can report on, and instead of just pure violations of law. And an employer can't, as sort of the bedrock principle here, take retaliatory action for employees for doing making these types of reports. All right, an interesting one here. Military and veteran status protections under Illinois law. Certain groups of military and armed forces receive employment protections for when they're absent from military service and therefore have to leave their employment. So that group, as before this amendment, covered Army, Navy, Marine Corps, Air Force, Coast Guard, and National Guard. Now it's adding U.S. Space Force. So for anyone who happens to employ a U.S. Space Force employee, I personally haven't encountered that yet, but we know some folks might. Those people now receive the same protections that the other members of armed forces receive.
Okay. So next we have updates to the Illinois Wage Payment and Collection Act. And basically this is just a requirement that employers maintain copies of employees' pay stubs for at least 3 years after the date of payment, regardless of whether the employee remains employed or not. That requirement stands. The pay stub must be in electronic or paper form, and the act also now requires an employer to provide an employee or a former employee with a copy of their pay stubs upon request and within 21 days of that request. The employer can require the request be made in writing, and the employer is not required to comply with that request more than 2 times a year. So they have to provide the pay stubs twice per 12-month period and upon request. And the employer does not have to grant the request for pay stubs if the employee's request comes in more than a year after that employee has ceased to be employed. So after a year post separation. Next, we have updates to the child labor law, which restricts employment for minors and increases employer obligations. Minors is defined as under the age of 16. So, in terms of hiring, the act requires that Illinois employers obtain an employment certificate authorizing the minor's work. So, in order to obtain that certificate, an employer must provide the minor with a notice of intention to employ, and the minor must then submit that notice to their school's issuing officer. And this must be maintained along with other information, typical that an employer maintains, such as name and address, date of birth, as long as the minor is employed, and then 3 years after that. On the next slide, we outline the restrictions that relate to a minor's working hours. So, as you can see, minors can't work for more than 18 hours a week or 40 hours max when school is not in session. There's also restrictions related to the 24-hour period, and distinctions based on the time of year and basically when school's in session or not, which affect the amount of hours and the times in which minors can work. I saw a question about whether if the minors during the summer, does the minor still needs to submit? My understanding is yes, based on the language in the amendment. And I assume that means the certification. Okay, yes. On the next slide, we just lay out some additional requirements by the act. So certain occupations are prohibited to employ an individual under the age of 16. This includes factory work, mechanic work, security positions, construction, and others. Those are just to name a few. And the act also requires that if you employ a minor, they must be supervised by an adult 21 years or older. If they work 5 consecutive hours, they are entitled to a 30-minute meal break. There's a notice requirement, typical of other employment statutes, that it must be posted in a conspicuous space. So I see a lot of that in employer kitchens, might be included with a handbook. And if there is an issue with a minor, meaning if they get injured at work or, God forbid, worse, there are certain notice requirements, and you have to notify the Illinois Department of Labor within 24 hours of that happening. The act also provides a pretty robust ability for the Illinois Department of Labor to investigate and enforce compliance with the act. It can be at reasonable times and as often as possible. There's also civil and criminal penalties that range from $500 to tens of thousands of dollars, depending on the violation and severity. Next, I want to dive into a more significant change in the law over the past year. This is the Worker Freedom and Speech Act, which was signed into law last year and prohibits employers from holding mandatory meetings to discuss employer views on religious and political matters. It provides that employers cannot discharge, discipline, or otherwise penalize an employee or threaten to do so because the employee either does not attend or participate in a meeting, or declines to receive or listen to employer communications. And this has to do with meetings or communications based on an employer's religious or political matters, which is specifically defined within the statute. And I wanted to highlight the political matters definition because it does include elections, political parties, changes to legislation, regulation, or public policy, but it also includes the decision to join or support any political party or political civic community organization, which expressly includes labor organizations. So many of you may be familiar with the meetings referenced in this act as captive audience meetings, meaning that when there is a union campaign or a union wants to organize employees at a certain workplace, um, employers have traditionally been able to have a meeting to voice their opinion on unions, which is now being affected by this new legislation. Um, so this law essentially seeks to diminish what has been important for employers in communicating with their employees during a union campaign. And it is currently being challenged in court because um, it's the argument is that the act is preempted by federal labor law, meaning the National Labor Relations Act, which has traditionally protected employer speech in that regard, and also based on an employer's First Amendment rights. So this litigation is still pending, but we just wanted to flag it. Also important to note about this act, employers may still conduct meetings involving religious or political matters if attendance is voluntary. It also doesn't affect an employer's ability to communicate info necessary for employees to perform their job duties. And further, employers can require employees to attend trainings intended to foster civil and collaborative workplace or to reduce workplace harassment or discrimination. The act also goes through other exceptions that may apply, such as higher ed institutions, legislative bodies, non-for-profits, etc. So I just wanted to, highlight that employers should be aware of this act and proceed knowing that currently the act does permit employers to conduct meetings to share opinions on union issues if the employees' participation is voluntary, which is really now key. So just tread carefully, review policies, and ensure that management is trained on their obligations under the act and I guess the parameters of their communications, and make sure that the voluntary nature of any and all meetings that could fall under this act are well documented to prevent claims to the contrary.
All right, so now some bills signed into law. The Dignity in Pay Act. So the Dignity in Pay Act applies to employers who have Section 14C certificates. For those not familiar, Section 14C certificates allow employers to pay workers who have disabilities less than the minimum wage. So Illinois had 14C exemptions. So currently, if an employer has a 14C exemption, they can pay a worker with a disability less based on their productivity relative to that of a worker who does not have a disability. However, this could result in certain jobs for a sub-minimum wage for workers who have disabilities. So now Illinois has passed this amendment, which is going to mean that these exemptions are no longer permitted. So anyone who has a 14C exemption by 2030, these are going to be phased out. And then there's a task force associated with this phase out. And I see a question in the chat I want to jump back to real quick on these the personnel records. Our question is, does this mean that employees are entitled to all versions of policies over the course of their employment? And is this limited to HR policies or all policies? So that act says policies that bind the employee during their employment. So if there was a version of the policy that the employee was never subject to or wasn't in effect, those versions don't need to be produced. everything else would. So let's say that there was a change in policy while the employee was employed, that would be both versions. And HR policies or all policies, you know, policies that bind an employee during employment is going to be more than just, you know, the employee handbook. It could be a standalone policy about confidential information or something like that. I would say err on the side of caution and presume that it is a policy that should be produced. If you have specific questions, I would encourage you to consult an attorney, especially if it's a sensitive document or a document that you're concerned about producing for some reason. And finally, some minor changes to the one-day rest in 7 Act. So the one-day rest in 7 Act, that had existed before. That's not what's changing. So for those not familiar, the one-day rest in 7 Act is sort of what it sounds like. It requires employees to get 1 day of rest for every 7-day period. So that's a 24-hour rest period in every 7-day work period. If for some reason an employer needs their employees to work through the 7 days. I've worked with employers where this has happened before, say in the sports industry, where there might be 10 games in a row, and so all the employees are going to need to be there past their 7-day rest period. The employer has to get a certificate from the Department of Labor that they're allowed to do this, and still the employee has to voluntarily work that 7th day. So those are the key aspects of the one-day rest in 7 Act, including small rules about breaks, a 20-minute break for every 7.5 hour shift, and then subsequent breaks for longer shifts. Now, the amendment prohibits employers from discharging or otherwise taking any action against or discriminating against, retaliating against, or otherwise, adversely changing someone's employment conditions because they've exercised their rights under the one-day rest in 7 Act. That could be making a complaint to the Department of Labor, the Director of Labor, their representative, or starting some proceeding under the Act, testifying about a violation of the Act. So the requirements remain. Employers still need to be aware that, if you're going to have an employee working more than 7 days, you have to obtain these certificates. Make sure that the employees is working that 7th day voluntarily, even if you have the certificate. And now be aware that there are increased rights for employees to challenge any violations and receive protection while doing so.
Okay, and looking ahead, Hope and I just wanted to highlight one piece of legislation that is set to go into effect January 1st of next year, 2026. And that is an amendment to the Illinois Human Rights Act targeted at the use of artificial intelligence or AI in employment decisions. So this protects prospective and current employees from discriminatory AI practices at certain defined touch points in the employment process. So this expressly includes recruitment, hiring, promotion, renewal of employment, selection for training or apprenticeship, discharge, discipline, and tenure, as well as the terms and conditions of employment generally. And employers cannot use AI in a manner that has the effect of discriminating against employees on the basis of any of the defined protected classes under the Illinois Human Rights Act. And they cannot use zip codes as a proxy for discrimination against a protected class. Employers also must provide notice to employees if they do use AI throughout the employment process. Excuse me. So employers should just generally be aware of if they are using AI to ensure that their use doesn't have the effect of discriminating against employees or prospective employees. Consider what your process is and if there are safeguards in place, such as human oversight or effective training on anti-discrimination laws and requirements. So with that, I know we're over time, so I just wanted to thank everyone who has attended today. If there are any questions, please let us know or follow up with us via email, and we are happy to connect and discuss with you. The presentation today will be available to you. I believe it'll be sent via email, and we're also going to be posting a recording online that you'll have access to as well. So with that, thank you all very much and have a great rest of your day.